Good evening, everybody. I want to welcome you all to this webinar, second part of a series that Gordon Holmes and Liz Holmes are doing for us. Tonight, you're going to learn about guardianship and the ABLE account. My understanding is, Gordon and Liz, is that you'll be taking questions throughout. So if you have a question, just put it in the Q&A and they will respond to it, or in the chat, we'll be monitoring both. So I'm just going to let them take it away. Thanks, Liz. Thanks, Gordon.
Of course. Well, good evening, everybody. Thank you so much for giving us some of your evening time to share this important information. As Dr. Pratt said, my name is Liz Holmes. I'm an attorney. I'm an estate planning and elder law attorney, and today's focus is guardianship, although my practice does go beyond that. That is the focus for tonight. So if you'd advance the slide. So we're going to be talking about what is guardianship. As with any legal presentation or financial presentation, this does not replace an initial consultation. So it shouldn't be taken as like fact specific, because every case is different. But we're going to go over what is guardianship, the terms, some Indiana laws, the types of guardianships, and you can see the rest of that. So guardianship is a legal relationship between a capable adult, the guardian, an ward, or an incapacitated person, otherwise known as a protected person, for whom the guardianship is maintained. So up until the age of 18, if you have a loved one with special needs, you are their natural guardian. But upon the 18th birthday, they are, according to the law, an adult and able to do everything by themselves, for themselves, without any help from anyone. But often, as we know, that isn't the case. And so that's why guardianship comes into play. So a protected person, otherwise known in Indiana as an incapacitated person, would be the reason for the guardianship in the first place. The petitioner is the person who initiates the filing for the guardianship, likely with the help of an attorney. And the respondent is the person for who the guardianship is sought after. Often I hear guardian or conservator interchanged. It's not quite the same thing. With guardianship, and you'll see in a future slide, there are two main types. There's guardian of the person and guardian of the estate, and we'll go over that in a little bit, but know that a guardian over the estate is the same thing as a conservator. So both are guardians, guardian of the person and estate, but conservator is strictly over the estate. And then you see the trustee, which goes a little bit out of the scope of the presentation, but a little bit of a teaser for next time, I suppose. The trustee is the person in charge of trust. Next slide. So guardianship laws and rules vary by state as to how guardianships are obtained. It does depend on state laws, and it's fact specific. So you'll want to be careful about pursuing guardianship in the state you live in. And then the example on the slide is that up until recently, Kentucky was actually having jury trials for guardianship hearings. We do have a question. At the student's 17th birthday and ACR, the TOR required to share information regarding turn 18. So at the I generally recommend, if I'm given the option, to have somebody approach me about 6 months before they turn 18 to start the process. Sue, so that they can file it before the 18th birthday, but yet have the guardianship obtained after or on or after. And that's a really important distinction. A lot of people think that you can go in early and get it done early. It's best to wait, because why would you pay for something that you already have? For one, if you're their natural guardian. And so you would want to wait until 18 to actually go to court. The process in Indiana, Sue, that's great. We're going to talk about that. So let me just get back on track here. Go to the next slide, please. Next slide. Thank you. With the types of guardianships, there's a temporary or a permanent umbrella. Temporary guardianship is in an emergency kind of situation. So often I find that if you are in the end stages of making last minute life, end of life decision making, that could be deemed an emergency. Unfortunately, a person turning 18 as much as it may be an emergency to you, is not an emergency to the court. So you'll want to make sure that you time that as best you can. And with that being said, COVID has kind of put a wrench in things with regard to scheduling too, because the courts have been backed up as well at times. It depends on the county. So you have a full guardianship, which would be person and estate. Then you have a limited guardianship, which could be either person or estate, or even more limited to specific events that need to be held. And then those are the two types, but you can have more than one guardianship, or more than one guardian rather, co-guardians or sole guardians. Everything has a cost. I wish I could do what I do for free, but it doesn't quite work that way. My assistant insists on being paid and I have bills to pay, so it doesn't quite work that way. But the cost does vary by attorney, candidly, and how they charge. The filing fee in Indiana, at least, is $182.75. It's actually $177, but because they only allow us to pay via credit card, they add a $5 and change fee. So I typically bill the client for that, since that's part of the fee. And then beyond that, it just depends on the county and the parameters and scope of work. And then there are different forms. I'm not sure what this AOC numbers are. It really depends on the county, and some counties have different forms. And then the attorneys themselves may have templates that they work with, like I do regularly. And then you can go forward. So really, and this is great information for you to have, know that we start off an adult guardianship, because that's what most of the time, I don't know what AOC means, Sue. I'm going to focus on telling you the Indiana experience. I know that my dad and his staff worked hard on these slides, but I'm going to skip over that and talk about the actual experience. So every adult guardianship starts off with a physician's report indicating what the incapacity is. And then, because that's what we want, why are we doing the guardianship? If you compare that to a power of attorney, where you retain your own rights and have somebody to help you in the wings if it's ever needed, versus a guardianship where you're essentially resetting somebody's adult clock to minority, then you need a physician's report to detail that out. Then once you file that, or get that rather, we draft a petition. The petition details out what we're asking the court to ask. And then we file that with the court. And generally about 30 days, although it varies, from the date of filing is when we get the physician's report. Or I'm sorry, it was when we get the hearing date. Next slide. So we file everything. Sometimes we're given the option of scheduling. Sometimes we're not. It just depends on the county and how friendly the clerk feels that day. Sometimes counties like Marion County, for example, has a guardian ad litem, which is a representative of the court. And you can see they validate that the appointment is in the best interest of the individual. They are actually a representative of the court that some counties require. This morning, I had a guardianship case in Fountain County, and a guardian ad litem had been appointed for that, just to make sure that no one was tricking anyone into a guardianship. So that's just basically the requirement of that. As far as the proof regarding on this slide, it's a physician's report and evidence, whether that's via Zoom or in person, depending on whatever evidence you have to present. Next slide. This is a really good topic, a liability of a guardian. So a lot of times I'll have clients not want to become somebody's guardian because they're worried if their ward or incapacitated person or loved one commits a crime, that they will too be responsible for that crime. It's not quite how it works. You know, if you steal a pack of gum from a grocery store, you and you alone are charged with that crime, not your guardian. Now, along those lines, it's important to know that you are responsible to the extent you can help them find legal representatives, legal counsel, but you're not liable. Only to the extent that the person has funds are you liable. A guardian can be removed, and this is often candidly harder to remove a guardian than it is to put a guardian in place. And that's because every adult guardianship, again, starts off with a physician's report that details out the incapacity. So in order to get out of a guardianship, it really happens in one of two ways if it's an adult guardianship. And that is if they've died, the person has died, or if they have regained capacity. Now, if it's a minor, that may be they've turned 18, but it just depends. And generally speaking, there's only 2 ways out. Now, with that being said, you could have a successor guardian appointed, but the guardianship would still exist. So it just depends on the facts at hand. Next slide. So a guardianship, and this is in general terms, again, this is not, fact specific, it just depends on your case, terminates when the protected person reaches 18, or if it's established, if it was established before 18, if the person marries, it can be terminated. It doesn't always terminate. A guardian can give permission to marry, to have their person marry, but that does not mean that they're not under a guardianship anymore. And I already kind of alluded to this, if they die or if they're no longer incapacitated. And then with regard to the estate piece, if there are no funds that the court needs to monitor, then often the guardianship of the estate gets terminated. And then if somebody moves, and this is very important, if somebody moves to a different state, this is all important, of course, but if somebody moves to a different state, then you need to move the guardianship to where that person is. It doesn't have to be instantaneous. It doesn't have to be right away, but you do need to make sure that where the person is where the guardianship is situated. Next slide. There are alternatives to guardianships, and I've kind of alluded to a power of attorney already. So the difference, again, between a power of attorney and guardianship is that under a power of attorney, you have your own rights. You are a fully functioning adult. You are able to do everything by yourself, for yourself, without any help from anyone. Under a guardianship, what you're alleging is that the person is incapacitated. And I know I've used that word a lot tonight so far in the presentation. I don't mean to be unfriendly, but that is the word that is the definition of why a guardianship is needed. It's not as simple as going to the doctor, and I know my brother and my mom are very close, and my brother relies on my mom, and it's not because my brother can't, it's just because that's how they do things. Well, Matt doesn't need a guardian, but somebody who answers yes to everything that doesn't comprehend what the question is may need a guardian. It just depends on the situation. So we're supposed to pursue, as you as parents and loved ones, and myself as an attorney, are supposed to counsel to the least restrictive alternative, and that could be power of attorney. That could be guardianship. There's something else called supported decision-making, which has been presented as something new, but it's candidly really not something new. It just makes the point that you need to not assume that guardianship is the first stop on the route, So there are specific circumstances, like what if a surgery is coming up and they just need a panel of people to consult, then that may be appropriate. But in most of my cases, where a parent wants to become a guardian over their child turning 18, I don't want to limit them on how much they can help. So it's not always appropriate, but it just depends on the situation at hand. And then if you establish a trust, you may not need a guardian of the estate, but again, that I could do a whole presentation just on that. So if you could, next slide. A representative payee. This is something a little bit different than a guardianship, but we're going to talk about it anyway. So if you apply to be somebody's rep payee, and before I go further than that, okay, so Charlotte, what if you had not had a chance to learn about this and go through things and they're 18, almost 21 in our case? It's never too late to go for guardianship. I've done a guardianship over a 5-year-old because parents were too busy to adult and parent. I've done one over people turning 18, and I've done them over 91-year-olds with dementia, and older. So it doesn't stop you. You haven't missed the boat. I would encourage you, if that is something that you're wanting to pursue it sooner than later. But that's not to say you can't file it just because your loved one is over the age of 18. And then looking through all the option is what took a while, and we didn't have support for adult transitioning. Yes, I'm sorry that is the case, Charlotte. Unfortunately, there's a lot of bad information out there and incorrect information. So I'm glad that you're here tonight, and I'm happy to help you. My dad and I both are happy to help you in any way that we can. As far as a representative payee goes, that is the go-between between Social Security and the person receiving benefits. So the slides will be shared after the presentation, Charlotte, and the contact information we'll put in the chat as well, but that should be that should be shared afterwards as well. So a representative payee is the go-between between Social Security and the person with disabilities. So namely, when Social Security calls and asks questions, they can talk to you as representative payee versus the person with disabilities. And I always like to tell clients, no one really wants to talk to Social Security anyway. So it's helpful to have a representative payee manage that for you. That is very different, and this is a good point, very different than being someone's guardian. So if I have a case where a child is turning 18 and their only source of income or potential source of income is SSI, I generally will not go for guardian of the estate, because when you apply for SSI, you want to go through Social Security's process to become representative payee. Social Security will not care if you are a guardian of the estate. They will still make you apply to be representative payee. So it's not as though you're appointed as guardian of the estate and then automatically you're representative payee. I wish that was easier for you, but it's just not the case. And then Social Security at times will ask for records and an accounting of how the money is spent, because that money needs to be spent on your loved one with disabilities. That is the point of that money. So not always, but sometimes they do ask for that. So if you are representative payee, know that the onus will be on you to make sure that the records are kept, because Social Security has a bad habit of thinking they're always right and taking 2 to 3 years to admit that they were wrong. And by then it's just been more of a pain for you than necessary. Next slide. A healthcare representative. This is, if somebody says power of attorney, they're largely talking about making financial decisions. A healthcare representative is somebody who is making your healthcare decisions in the event that you lack capacity to do so. A power of attorney document, really quick, because I noticed that's the last line of the slide. A power of attorney document is only made when you have capacity. It cannot be made when you've lost capacity. So it's imperative to make sure that you don't wait too long, because if you lose capacity or the person that you're planning for loses capacity, then guardianship is the only option. And as much as I love to go to court, because it is kind of fun to, go in front of the judge and get to know the judge a little and have fun with the family, if we can avoid going to court, that would be my preference, and definitely the families. A durable power of attorney is for financial decisions only. And durable means, what if I lose capacity later? Then it's still a valid document. But a power of attorney, otherwise known as an attorney in fact, and no, you don't have to be an attorney to be an attorney in fact, is the person and the role played under this document. It remains in full force and effect, again, hence why it says durable, if they become incapacitated or disabled later. And largely speaking, power of attorney documents expire at death. There is a little bit of overlap with regard to burial, but generally speaking, it expires, which is why a will is important, which again is out of the scope of this presentation, but I just thought I would throw that in there. So bonus, next slide. There are specific power of attorneys documents that you can draft, much like with guardianship, there are limited ones. So sometimes if a parent needs to put money or a loved one needs to put money into a special needs trust and they don't have authority, I can draft a limited power of attorney for that. What if a specific circumstance is coming up and a decision needs to be made? We can draft a limited power of attorney document for that. So that is that. Next. A trust, and I'm speaking about a trust in general, is a relationship where property is held by a trustee for the benefit of a beneficiary. Sometimes it may be the same person, it just depends. But a settlor or a trustor or a grantor is somebody who transfers property to a trustee. So often when I have a special needs trust, especially a third-party special needs trust, the parents may very well be the grantor and the trustee at the same time. Now, when I get into trust and I talk about them, often my clients' eyes glaze over and they feel overwhelmed. And I understand it's a lot of information, but Indiana is a dry trust state. There is no requirement for you to put $1 into a trust today or tomorrow or ever, really. I mean, I hope that the documents I draft are used and utilized to the best of my clients' needs. But often this is where people like my dad come into play as far as helping beneficiary designate items to the trust to make sure that benefits like Medicaid, which are hard fought for, and Social Security are not lost, and so that their loved one with disabilities can have the best life possible. There are different types of special needs trusts. Just broadly, there's a third party, which is where it's somebody else's money other than the person with disabilities, and then there's a first party. The first party is one where it is only the person with disabilities money and can come up in a number of settings, maybe a direct inheritance if planning wasn't done properly, maybe a settlement if you sued somebody and got money that way, for example. There are protective proceedings that can be done without the appointment of a guardian. Those are rather limited in my experience to date, but they are if they're fearful of their safety and need to be protected. So the parents of a minor, joint or as a survivor, may execute a power of attorney under the IRS code. I've also done power of attorney documents where a parent has allowed somebody to take their loved one who's a minor to the doctor, or even as guardian. You know, if the guardian's not available to go to the doctor, at times the power of attorney can be helpful in limited circumstances. Next slide. So guardianship is really fact sensitive and case sensitive. I know that the process can be overwhelming. Some people elect to do guardianship on their own and unfortunately end up with a big mess. It's really not as big of a headache as it sounds if you hire an attorney, candidly. Not every attorney is the same. Not every attorney is as knowledgeable about guardianship as others. There are some out there that try to do every area of law. I really think that that's a disservice to the community, especially the special needs community, because guardianships are really important when they're needed. And it's important to have a knowledge of special needs trusts and Medicaid as well, or to be mindful of your limitations when representing clients so that you guys can be served to the best of your ability, to the best of my ability for you. For example, like I don't do divorce law. I don't do criminal law. I have friends that do. They have the best stories at parties, but I focus on estate planning and elder law as an example. So with that, I could tell a lot of stories, but I want to be mindful of the time and respectful and make sure that you have as much information and value as you can out of this presentation. I think I'm caught up to date on the questions. And so with that, I'll turn it over to you, Dad, a few minutes early.
Okay, just a couple of things that may be of interest to our group. One is reporting. Questions sometimes come up of, do we submit a report to the court after the first year and then every other year thereafter? And some counties require reporting and others don't. Could you just mention what's involved with that?
Sure. If you have guardian of the person, a report of the person is due. All of that is a filing. It's not going back to court and going through the whole process again. It's how are you doing? How is your loved one doing? Is the guardianship still needed? When did you last see them? It's a pretty straightforward process compared to other states, potentially. I'm only familiar with Indiana law because that's where I'm licensed. And as far as timing, it really depends on the county. Some require every year. Some of them require 1 year every 2 years. Most tend to require every 2 years. If you haven't heard from your court, if you've already obtained guardianship, I wouldn't freak out. I would just acknowledge that it needs to be done. And I'm certainly happy and willing to help you with that. Now, beyond the report of the person, if you have guardian of the estate because you have come into money, inventories and accountings are required. And that, again, just depends on the court and depends on the facts at hand.
All right, wonderful. Well, thank you, Liz, for such great information on guardianship. Next, this evening, we're going to move into a discussion about ABLE accounts. And so give me just 1 minute here to move to the ABLE account presentation. And okay, could anyone confirm that the ABLE account presentation is up? Does everything look good? Okay.
It looks
I
great.
see it.
Looks
It's up.
great. Yeah.
Okay, great. Thanks, everyone. I appreciate it. Just didn't want to lose anyone. Okay, so this evening, I think you'll see ABLE account in a different perspective. We have the latest up-to-date information about ABLE accounts, what they are, what they're not, how they can be used, etc. And we also have some many case studies built into this evening's presentation. And so hopefully you can see the problems that ABLE accounts are able to solve and how they can be helpful. There are also limitations with ABLE accounts. So understanding it strategically, how it can be used is very, very important, and then avoids disappointment. So the ABLE Act, and we'll see if there we go. Okay. So also known as the Stephen Beck Jr. Act, named after Stephen Beck, who helped shepherd the legislation over a 7-year period. He passed away on the eve of its passage, and so honoring him for his tireless effort to help get the ABLE Act through Congress, it was renamed again in his honor. Of course, known as Achieving a Better Life Experience, ABLE, signed into law at the end of 2014 as a part of the Tax Increase Prevention Act. This law allows eligible individuals with disabilities to have a tax-free savings account modeled after the 529 college savings accounts. In fact, that was the idea initially when it came about. We can do 529 college accounts for our kids that are college bound, but what about our children with special needs that may not be college bound? What saving opportunity is there for them, especially with the limitation imposed as a result of government benefits often involved? And as we discussed last week, the limit in Indiana for an individual on Medicaid and or SSI is $2,000, so you can't get very far with saving. But as most of you probably know, an ABLE account, if properly set up and administered and eligibility in place, it does not count against the individual with special needs. So legislation has been passed in most states. There is a website with information about ABLE accounts around the country, and that's www.ablenrc4nationalresourcecenter.org. The Tax Cuts and Jobs Act of 2017 brought enhancements to ABLE accounts, and we will talk about that in a moment as well. So ABLE accounts have changed since they first came about in 2014, 2015. But eligibility, so who's eligible? Who can get in on this? Must be blind or disabled prior to the age of 26. So the intent is that a person either meet the Social Security definition of disability or have a condition or diagnosis that's going to result in their meeting the Social Security definition of disability. So how can we measure? Measures would include if the child is on a Medicaid waiver. That's an indicator that they may become Social Security or SSI eligible at age 18. Or if they would otherwise be eligible for SSI, if not for family finances, another example. But under current law, the diagnosis, either Social Security disabled or diagnosis showing Social Security eligibility is needed before 26. All right, there is a move afoot to raise that age limit. So in the coming years, it got stalled because of COVID, but in the coming years, we may see that age limit raised. So the opportunity for more individuals to take advantage of this. But who would the age 26 currently exclude? It would exclude someone who did not have a disability and as a result of, as an example, a diagnosis, an auto accident, or an event that occurred at their age 30 rendered them disabled. Because the disability did not originate prior to age 26, they would not be a candidate for an ABLE account. If age criteria is met and they're already receiving SSI, they're automatically eligible. If age criteria is met and they're not receiving SSI, then it's a matter of a certification from a doctor, in other words, evidentiary of their diagnosis regarding eligibility. Okay, so what can you do with an ABLE for someone that's eligible? You can contribute to it. The consumer themselves can put money in. So if they had a part-time job, they could save their earnings. Parents, grandparents, others can contribute. Birthday money, Christmas, holidays, you name it, monies can pool in an ABLE account, can be invested to grow. And again, it does not count as a resource for the individual regarding their SSI and or Medicaid. Maximum is $15,000 per year. It's tied into the annual gifting limit. And so an individual that does not have earned income, that is a an individual with special needs or disability that does not have earned income, their limit is $15,000 a year. They can only have a single account, and so it doesn't matter how many people are lined up to contribute or help. The combination of all contributions made to that single account in a given calendar year cannot exceed $15,000. $100,000 is the maximum for SSI. That is, if they exceed the $100,000, SSI is suspended until which time the ABLE account balance were to drop below $100,000. For Medicaid, the limit in Indiana is $450,000. And so if they rise above 450, in addition to having off SSI, they will lose their Medicaid. With an annual limit of 15,000, obviously, ABLEs have not been around long enough to get anywhere close to the 450,000. So we may or may not ever see that issue, but I suppose one could get to the 100,000. Okay, so when I finish this current slide, I'll go to the chat and start answering some questions. If SSI recipient ABLE account goes over 100,000, again, SSI is suspended. One account per person, and contributions can be made by anyone, beneficiary, family members, friends, etc., and must be made in cash, meaning you cannot gift a used vehicle. You cannot gift stock in your favorite tech company. These ABLE accounts are set up where they will take a transfer, a check, an electronic transfer, a transfer of cash, this type of thing, but not securities, not property, etc. Okay, let's see here. All right, so a question comes from Gary. Our son qualified for Medicaid waiver. We opened ABLE and funded while seeking SSI. If SSI is not approved, must I close the account? What type of evidence would be good enough for ABLE qualification, but not good enough for SSI? Great question. And the answer is Social Security will sometimes turn people down, people that we would consider to be disabled, but their definition is more restricted. And I think this is the point where I would mention, you indicated if a son is not approved. Actually, if he's not approved for SSI, instead of closing down the ABLE account, I think the word that comes to mind for me is appeal. So I think as many or more people are approved for Social Security on appeal than they are initial application. I think the approval rate on the initial application is somewhere around 30%. And so I would not give up. Sometimes it feels like who's going to outlast who, and just do your very best to make sure you're going to outlast Social Security and not give in or give up. There are attorneys that specialize in government benefit appeals, including Social Security, and Liz or I, either one, would be delighted to help get you connected with an attorney that eats, sleeps, and breathes appeals to government benefit decisions, so that you have the full force of an expert in what we're looking at here to launch an appeal, et cetera. I have seen Social Security appeals sometimes run 1, 2, as many as 3 years. And so you just don't give up. And it's always best to make your response within the time limit allowed, frequently 60 days, because as long as the claim remains active and you do not allow it to expire, then when you eventually prevail, Social Security will have to back pay to the first calendar month after the month of initial application. And the back payment can be in the thousands, if not tens of thousands of dollars, depending upon how long the Social Security claim continued on. So we as a part of this series, Liz and I are making available a free follow-up consultation. And I'd like to discuss this further with you, Gary. So my suggestion would be to take advantage of the free, I did say free, follow-up consultation so that we can talk about the claim that has been made and how the claim may be strengthened and what the appeal process involves. Great question. Thank you. Thank you so much for that. Let's see here. Okay. All right. Okay, enhancements made to the ABLE Act. This came about 3 years after ABLE was first available. So tax and penalty-free rollovers of up to $15,000 from a 529 account. Frequently, this is maybe a 529 account for a kid with special needs, but it ends up they're not able to use the funds for education beyond high school, this type of thing. And so funds can be rolled over to a 529. You also, of course, have the option of changing the beneficiary and allowing one of the siblings to utilize the funds. Or if you have a sibling that has not used up their monies, then the beneficiary can be changed and this can be rolled into a 529. Rollover of certain retirement funds. More and more of our kids with special needs are getting part-time employment as the labor market once again starts to get tighter. And just had someone in today working at McDonald's for $13 an hour. Who would have ever thought working at McDonald's would pay $13 an hour? So again, more and more of our kids with special needs are picking up employment, part-time employment, this type of thing. And so in some cases, they're becoming eligible for retirement accounts, et cetera. So I do not necessarily encourage at every opportunity taking advantage of a retirement fund, but if it's inevitable or required or automatic, as sometimes it is these days, having a retirement account through an employment is not the end of the world. Typically, while they're actively employed, it does not count against them as a resource. And then if they were to leave that employment, the retirement account balance, at least in some cases, can be rolled over to an ABLE account so that the funds don't have to be lost or wasted. Credit for qualified retirement savings contribution can be available. And then last but not least, that part-time employment will actually raise the ceiling on what they can contribute. So annually, the limit for someone that has employment is $15,000 plus their gross annual income for that respective calendar year, capped at $12,760. So in that situation, a person could contribute over $27,000. So ABLE is quite generous in terms of the amount that can be set aside. Okay, I'm often asked, okay, ABLE sounds great, but what can you spend the money on? It's no good if you can't spend it or access it or use it. And the answer is a lot. So here's just a sampling of qualified disability expenses. Lots of opportunities to utilize funds that accumulate in an ABLE account. So you can kind of go down the list, but if it enhances the quality of life, if it's an investment in the consumer, chances are you can make a withdrawal from an ABLE account to pay for it. Okay, one thing I should mention by way of full disclosure, when ABLE account the legislation was passed because it allows the consumer to put their own money in there. So what do I mean by that? Let's say that a grandparent passes away, leaves $5,000 to each of their living grandchildren. Well, one of your children is a grandchild, therefore they're eligible to receive $5,000. Well, you know, if they receive $5,000, there goes SSI, there goes Medicaid, there goes Medicaid waiver services. You've got a big problem. So the good news is that an ABLE account could be a quick and easy way to set aside that $5,000 inheritance so that the funds are not wasted, they're available for future use, and it does not undermine their continued eligibility for government benefits. So that's just one example. But keep in mind that because the consumer's own money, their inheritance, their income from part-time employment, their back payment from Social Security, et cetera, because their money can go into an ABLE account, the state can decide to impose a lien upon the ABLE account at the time something happens to them. Indiana presently is not enforcing that lien, but things can change and the law certainly does allow them the opportunity to do so. So ABLE accounts are what I call put and take accounts, opportunities to accumulate for future use, for needs or wants that occur in the future, but they don't lend themselves well toward massive accumulation plans of maximizing it like you might think of 401k or that type of thing. Because at 100,000, you have SSI issues, eventually potentially Medicaid issues, and then the possibility the state will impose a Medicaid lien at the time of their death. So they're mostly for convenience and smaller amounts of money in the hundreds and the thousands, but probably not tens of thousands of dollars. Okay, so most states have adopted ABLE and Indiana is no exception. So Indiana has Invest ABLE, run together, Investable. And it's managed here in Indiana by there's an office that's in charge of that. And they do a wonderful job. We work with them frequently. States can decide to contract with another state. So some states don't have their own plan, but they tap into another state's plan. If any of you live in Southern Indiana, as an example, Kentucky has the stable plan, as does Ohio. So different states, different names, different plans. They do bear similarities like 529 college accounts state to state. One thing that I should mention is that there is one ABLE account that is advisor assisted, and that's the Virginia ABLE America through American Funds. American Funds also handles the Virginia 529 College America. And so if you're familiar with American Funds or have experience with them and want to utilize American Funds, then an advisor such as myself can assist you in setting up your Virginia ABLE account. You do not have to live in Virginia. You don't have to have anything to do with Virginia. It's just that the American Funds plan is based in Virginia, although it's available throughout the entire country. So here in Indiana, you could set up the Invest ABLE plan, or you could, with the assistance of an advisor, you could set up using American Funds, the ABLE America. So there are options, different choices to be made. So opening an ABLE account, most of this is online. So with Indiana's plan, you would go on to the Invest ABLE website, click the button that says start saving or open an account and start entering data. Usually a half hour later, the account can be set up pending receipt of any last minute paperwork, but these are typically not all that difficult to establish or set up. You can have a debit card as far as accessing funds, so you can seek reimbursement from the plan for an expense incurred, or if you want a debit card with your ABLE account, then you could spend utilizing the debit card. Okay, things to consider with ABLE. An ABLE account may not be the best vehicle if. So these are situations where maybe let's not use the ABLE here. Inheritances, settlements, judgments, or contributions from beneficiary or family that exceed the maximum annual contribution limit. So if you're above the 15,000 or 15,000 plus wages, it exceeds what ABLE can absorb. Contributions are not coming from the individual with a disability and therefore could go to a third-party special needs trust, avoiding the Medicaid payback associated with an ABLE account. And we'll be talking about special needs trust next week. It's going to be an incredible evening, or not next week, excuse me, next month in the August session. And it's going to be an incredible evening because we're, with Liz's help, we're going to go into the different types of special needs trusts, first party, third party, Miller trusts, and pool trusts and so forth. So it's going to be a rich discussion of special needs trust, which is so important to the special needs community. Maybe the ABLE third bullet point would not be as good with a beneficiary with a disability whose origin or diagnosis came after their 26th birthday. The beneficiary cannot make financial decisions. Well, then it may not make sense for them to be in charge of an ABLE account. And ABLE accounts can be used in combination with other savings vehicles, such as special needs trusts, meaning it doesn't have to be an either or, you can have both. Okay, so finally, we're to the point of looking at some examples. So better suited for small settlements, unexpected inheritances, or savings of the consumer. Those are the ideal situations. So a small settlement, as an example, I had a family with a child that rode in the special school bus and was non-ambulatory. And I think a substitute bus driver or whatever took the special needs bus and I guess was not fully up to speed with how to do things. And unfortunately, the door with the wheelchair was opened appropriate restraints not put on, the wheelchair rolled out, fell out of the bus, and the young student with a disability face planted on the asphalt. Well, needless to say, there was a lawsuit that followed and eventually a settlement. I think the settlement amount was $15,000 or thereabouts. And so that settlement could go into an ABLE account. So that's an example of where an ABLE account could be a convenient way to handle a small amount of funds. Whereas if that $15,000 had been placed in a checking account or a savings account for the young individual with special needs, it could have cost them their Medicaid and waiver services. Here are some other examples. Oh, in fact, that was example 2 I just told you about. Okay, so example 1, grandparent dies and leaves $10,000 directly to each grandchild. For the grandchild with special needs, it must be spent, used to prepay final expenses, or it could be deposited into an ABLE account. So that's an example of where ABLE to the rescue. Then example 3, an individual with special needs gets a job resulting in earned income. They want to save some of it for a vacation, furniture, additional schooling, vehicle, etc. But they need to maintain their eligibility for SSI, Medicaid, and Medicaid waiver services. An ABLE account allows for funds to accumulate for future use without being subject to the $2,000 resource limit. So where ABLE is really good is with resource issues. Resource issues are where ABLE does a tremendous help. Okay, so these are things to consider with ABLE accounts, further considerations. ABLE accounts within limitations can address resource issues, as we just said, by sweeping the inheritance, legal settlement, paycheck 529, savings, or investment account into an ABLE account. The consumer is back under the $2,000 resource limit. What an ABLE account won't fix, though, are income issues. So resource issues subject to ABLE limitations, yes. Income issues, no. So let's look at a couple of income issues. Example 1, consumer age 22 is receiving SSI and has a part-time job, earning $500 per month. Placing his or her $500 paycheck in an ABLE account will not allow him or her to avoid the reduction in SSI, meaning for having earned income. Now, mind you, this person is 22. They are no longer eligible for the student earned income exemption that we talked about in our last session. So the way SSI works in terms of reduction for wages is laid out here. So they take the $500 in earned income, that $500 monthly paycheck. They take $85 off the top, $85 is forgiven. It's $20 of any income, $65 of earned income. A total of $85 is forgiven. Now we're down to $415. The $415 is then taken times 0.5 because for every $2 earned, there's a $1 reduction in SSI. Therefore, this person's SSI benefit would be reduced by $207.50, half of the $415. The ABLE account will, however, help keep the bank and savings and representative payee account under $2,000 for continued SSI and Medicaid eligibility. So the point here is stashing it in an ABLE account will not keep it from being considered on one's SSI benefit. But truly, the person is still ahead because a $200 reduction off of a almost $800 SSI benefit means their SSI is close to $600. $600 plus $500 in income puts them at $1,100 on the month. That's amazing. So usually it's better to work than not work, meaning your net dollars ahead for having employment. Example 2, a consumer at 35 is receiving $500 a month in SSDI from their own record of employment, meaning they worked part-time long enough to draw a disability off of themselves. They also receive an adult child benefit of $1,000 per month from a parent's record. That means a parent is either retired, disabled, or has passed away. They continue to work, earning $900 per month. They can save up to $25,800 per year to an ABLE account to keep countable resources under $2,000. And we have a hand we'll get to it momentarily. Thank you. But this will not fix it. They're exceeding the maximum $2,382 for Medicaid disability. So Okay, so what we're looking at is they're getting $1,000 in Social Security benefits off of a parent. They're getting $500 in Social Security disability off of themselves. They're earning $900, so now they're at $2,400. They have to stay under 2382 to maintain Medicaid disability eligibility. And so this is where a Miller Trust can be used. And we will talk about Miller Trust at our next session in August, because we're seeing increased demand for them as more and more of our consumers with special needs start working. Okay. Okay, so we had a hand up. Help me out. Can somebody help me with their question? Okay.
I see a comment that just says thank you.
Yeah, okay.
I don't see a
So,
hand.
Okay, so a hand was up a moment ago. Does anybody have, I'll stop. Before I move on, it may be salient to this slide. Anything? No?
So Gordon, Summer Martin has her hand raised.
Okay,
So do you want to answer her question now? I think she wants to talk to you, say the question to you, or
yes,
how do you
please,
handle this?
please.
Okay,
Can
Summer, I'm going to allow you to talk.
I pushed it on accident, but I do have, my son is in middle school and he does have a specific learning disability and he has an IEP. So I'm just trying to figure out, and I've been wanting to start a 529 plan. I have 3 kids. So like, if I should just go ahead and do the 529 or mess with the ABLE at all or not and stuff like that. We make too much to get any support from anything, but not enough to like do everything we want. So we're between, I don't know, we're middle America, I guess. So
yeah, you're getting squeezed. Okay.
Yeah.
So, all right, great question. Let me touch on several things quickly. Number one, there's very little downside to having a 529. So if you think your child may pursue post-secondary education, please understand a 529 account can be used toward private high school. It can be used for Ivy Tech. It can be used for Vincennes, 2-year, 4-year technical school. It's quite broad in terms of the education experiences beyond high school that it can be used for. Please also understand there's no age maximum, which means if his post-secondary education kicks in at 25 or 30, that 529 can be deployed at that point to pay for those expenses. You always, of course, can change the beneficiary on a 529. What a lot of parents are not aware of is that you can actually change the beneficiary to yourself. So if you or a significant other decide to pick up classes, go back to school, et cetera, or park it with you as the beneficiary to later change it to a grandchild. So 529s have a lot of flexibility. And as long as the 529 is not funded by your child, meaning you didn't fund it with money from his or her savings account or that type of thing, we have yet to see it be an issue in terms of Medicaid eligibility or even SSI eligibility at age 18, as long as it is not a UTMA 529. So that's kind of the story on that. I'd go for it. Set up a 529. Between the state tax credit in Indiana, 20% on the first 5,000 contributed, and the flexibility that you have with it, et cetera, I say go for it. Now, the other aspect of getting help, please know that if your child has a learning disability, has an IEP, this type of thing, even if they are currently diploma track or you have an expectation that they will graduate with a diploma, they may, I say may, be eligible for the Family Supports Medicaid waiver. And so we should probably have a conversation offline or perhaps take advantage of the free consultation to talk about the Family Supports Medicaid waiver, because it's kind of timely in that Dr. Pratt and Liz and I were just having a conversation right before we started this evening's workshop about the importance of engaging early. And frankly, oftentimes the waivers are easier to get when our child is younger because things are less predictable, and less predictable actually can make help come a bit easier than when it becomes more of a concrete black and white situation as they get older. So if your child's not on the waiting list for or is not receiving benefits under the Family Supports waiver, then that's something that you may want to consider in the interim in addition to a 529. I hope that was helpful.